thereby the petition wide IA 1418 of 2018 shall be restored to its original number. The learned trial judge shall dispose of the IA 1418 of 2018 as expeditiously as possible, preferably within 1 month from the date of receipt of the copy of this order. Order is ready. You can take it.
Serial number 3, T.B. Deswal, Violent Associates.
CRP 2757 of 2019. CRP is allowed, setting aside the order dated 18/11/2019 in IA 500 of 2019 OS 1824 of 2013, file of 7th Junior Civil Judge, City Civil Court, Hyderabad. There shall be no address to cause. Pending miscellaneous applications shall stand closed.
Serial number 4, Saroj Reddy.
Notice, issue notice to the respondent to court as posted 29/11.
Serial number 5, 6, and 7. And you are Dayanand Rao, A. Venumaharan.
Dayanand Rao request for that 2 weeks. That is that
Yes. Both counsel are present. At request posted to first West 112.
Serial number 8, M. Damodar Reddy, Pawan Kumar Pujari.
May I discuss? And for respond.
No, actually, see, but LRs have to be. Yes.
On required of the legal that
Hmm. 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 Hmm.
That period was completely now it's true by workshop run that automatically got this as a paper.
Hmm. On that, this CRP is preferred.
Yeah, only part of it.
In the CRP also, revision petitioner died or what?
Yes. It was time.
Revision petitioner. Hmm.
Except the repetition of that.
Hmm. 1 minute. Sir. No, this main appeal is the Sinam Abolition Act.
Yes.
No, you say that the CRP has been preferred on dismissal of LR application. Then you say that it is based on the dismissal of LR application. Okay. Other side, Pavan Kumar Pujari garu, Damodar Reddy garu. No representation for the revision petition and call. Counsel for the respondent is present. For filing counters, if any, in IS 2 of 2020 and 3 of 2020. Is there any stay in this matter? Posted to?
And he has not brought on the card as per after 1 period of
I understood, sir, but other side counsel is also there. Let us give an opportunity.
and context is not.
It's to 2020 matter. Okay. Posted to 22/11 as a last term pattern. Our counters, if any. Next.
Serial number 9, P. was Kodavastu, D. Mahadevi, standing counsel for
The degree holder.
Sir, in this IAs are there. Condon delay petition is there. Condon delay petition is there in this matter. IA 1 of 20. IA 1 of 2020. Let me see the proceeding sheet. IA 1 of 2020 is already condoned. It is already condoned, but still it is reflecting in the cause list as IA. Delay of 193 days is already condoned, but still it is shown as pending in the cause list. So the registry is directed to remove IA's petition, Charamani. IA 1 of 2020 is already ordered. And who is the other side? D. Madhavi? Yes. CRP is preferred by? Hmm. 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 Hmm.
Subsequently, regularly, award possibly conditional directly minus whatever 1/3 because already the connection will start balance. We find a calculation from they have to find a calculation. Conservative no level. They have find a calculation from we have find a without right. Approve the calculation from data and rejected our calculation which is incorrect. But what's very simple math. 50% amount, for example, I have say it is 100 rupees. 50% amount, they have to deposit 50 rupees. They have money to it. First of all, the direction of the amount they have directed. What they have done is 16.67% is standard. The reduction of that amount was balance amount they have calculated. So the balance fund they are calculating. Just I will demonstrate how calculation of the calculation. That way, can you see the order pass of the year?
Yes.
Here is the calculation of the DHR and ADR. But after the CRB rating, JDR to deposit 1/3 of the that is 33.3% at the rate of 2,500. In IA, 1 or 2018 and LAS from the course, so we get 24 meetings. The Honorable High Court directed the JDR to deposit 50% of the amount. JDR deposited 33.3%, and after the year 1 of 2018, deposited the balance of 50.7% of the dividend purpose. To make the JDR deposit 50% of the the calculation now reveals that the interest was also calculated and ordered to the Honorable. The percentage of the DHR. The IA number JDR can deposit 50% of the balance, but not 16.7% to make it to a loan application. Directly, the JDR came to the difference amount making a euro. Next week, go for the rest of the I will run both sides that I will go through the direction of and before I go, I want to use the JDR 50% of the 90% and after the IA, 1 of the meeting and everybody come to DHR and pay. Now I will take the today, calculation from a model. Page 11. Calculation sheet by the way, it is a data.
Hmm.
Second edition basically, value 3,000 market value total curriculum 2 lakhs out.
Hmm.
Amount awarded by the individual accepted level of balance amount paid to the district court order. It is for that 8 crores per year for total compensation paid 100% as per lower court orders that 17 crores 56 lakh from 7 crores 97.
Hmm.
This is the total amount up to this balance there was no dispute. We also calculated 17 crores. So 17 crores 56 lakhs, 50% balance works out to 8 crores. Percent balance.
Hmm. Hmm.
18, we have calculated how into this what are the more.
Hmm.
To 80 lakh benefit.
Hmm.
Column A is 17 crores 56 lakh 47 dollar. We also arrived to that figure.
Hmm. No dispute. Hmm. Okay.
17 crores
50%.
total amount.
50%. 8 crores. Hmm.
That's BFP.
Hmm.
50% of the amount because this armed directed them to deposit 50%.
Hmm.
So the 50% amount works out to 8 crores 78 lakhs.
Hmm.
And when the amount deposited in purchase to the other party CRP 5 crores 58 lakhs.
Hmm.
Because the earlier the CRP 1/3 amount was directed to deposit.
Hmm.
That is 5
That
crores.
has to be deducted. They already deposited that 1/3. Oh, okay. That has to be deducted. That is deducted.
Balance amount to be deposited to
Yes, 2 lakhs. 2 crores.
pay for from out of 8 lakhs 78,000 as they have already paid 5 crores 58 lakhs. The balance amount is 2 crores 96.
Hmm. Hmm. Hmm.
Then NGO in column 6 of the calculation memo, wrongly derivative figure come from. Here the difference is this.
Hmm.
We very simple amount for simple figure is 2 crores 22 lakhs 74,000.
Hmm.
Figure went out to the figure of 1 crore.
How that came?
Exactly, page 12 of the calculation memo.
Hmm.
Page 12
That is with interest. 1 lakh 9. That is interest, I think.
number 6, the amount to be deposited as per LAS number 1 crore 95 lakhs.
That is 16.67% interest. Interest. Hmm.
How wrongly they have calculated. This is very simple calculation. Page 18, our calculation. How we receive 8 crore 78 lakhs.
Hmm.
Already they deposited 5 crore 58
One
lakhs.
third.
The amount is 2 crore 91 lakhs.
Hmm.
So this balance 5 crore 58 and 2 crore 92. Total into 8 crore 70.
Hmm. Hmm.
The two figures product C and D
Hmm.
comes to 8 crore 78 lakhs.
Hmm.
We have miscalculated derivative figure of 1 crore 95 lakhs instead of 2 crore 90.
Hmm.
That I mentioned it in column here, last question is the earlier in column 6 of the calculation of page 80 lot.
Hmm.
Derivative figure of 1 crore 95 lakhs 16,244. The calculation of 16.67% by him on 11 crore 70 lakhs 98,000 is expressed incorrect. How he has calculated that 16.67 after deducting this 5 crore 58 lakhs from 78 crores, the figure will come to 11 crores. From that he has calculated 16.67. That is not correct. Now he calculated the 16.6 on 17 crores. So for that reason, there was a difference in between us. So simple figure is 2 crore 10 lakhs. Another mistake out of the the expense is correct. This 15.61 should be on 17 crore 56 lakhs. Then there is a shortage of the amount of 2 crore 22 lakhs minus 1 crore 95 lakhs, 97 lakhs 58,000 balance. So they are able to figure out 1 crore 95. We are able to 2 crore 92. The balance minus the difference is 97 lakh 28,000. Then what further mistake they have committed it? But the column F. The engineering column 7 of the calculation calculated the interest from 11/6/2017 to 31/7/2018 and the figure of 5 crore 80 lakhs instead of a figure of 11 crores. But the balance amount is 11 crores. From 17 crores, they have deposited 5 crores. The balance is 11 crores. And that money they have to calculate interest. Instead of that, they calculate interest on 5 crores. Extremely good. Wrong calculations are given. Simple arithmetical method. Executive court dismissal by calculation. Command approved in bracket. Then admitted to say, well, he arrived to a figure of 5 lakhs 23,201 as interest. If this calculation is expressly arbitrary, the interest will be calculated on the figure of 11 crore 70 lakhs. If interest is calculated on this figure, it works out to 2 crore 18,000 and 50% of it comes to 1 crore. That's what the endeavor came to a figure of 1 crore 95 lakhs 50,000 as principal and 49 lakhs 51,000 interest totaling to so and so. However, the petitioner is entitled to get an amount of 1 crore 48 lakhs. The 1 crore 48 lakhs were at due from 26 crore to 19. But huge amount were not, they were not deposited from right from 1918, 2018. Already 5 years passed by. This figure were at 1 crore 48 lakhs, simple arithmetical manner. 50% of the amount from total enhanced amount. Total enhanced amount is 17 crores. And as per the order from the Honorable Division Bench, I have entitled to get 8 crores 78 lakhs. Whereas for that, they have 8 crores 78, they say only 1 crore 95 lakhs. Instead of 2 crores 30. Very simple arithmetic calculation. The court should be mistakenly stated that Indigo deposited 33.33% first instance and 16.67. 33, 16 is okay. But how you have calculated that 16.67? That is important. Mistake committed by them. So this calculation number by me is recorded in principles of mathematics. It is nothing but law part is involved. Simple calculation. So huge amount 1 crore 48 lakhs is still payable by them as per the order of the Honorable. They have not given. CR plus 12 and if you directed deposit this amount, if further interest from 2018 because the Honorable Court has said you deposit the amount, 50% of the amount with accrued interest. That is the matter. I also buy the order copy ordered by the division court. The page 16 lot to be received. Page 16. Pending further order, they can be clear operation of gentleman and degree also. Subject to the abundant implicant abundant deposit to the credit of KOP, 50% of the enhanced compensation along with the interest accrued thereon till the date within 8 weeks from today. While computing is a 50%, credit should be given to the amount stating was deposited with having in purchase to the other payment to CRP. Court says you have to deposit 50%. While depositing the 50%, the credit should be given to whatever amount which we have already deposited. That's how the amount we have deposited. They are not properly calculated and they have given a wrong calculation amount of the executive court and executive court says and you would like to know that nothing is much.
See, both the council have filed calculation memos. See, what the council says, you have filed a wrong calculation by deducting all the amounts. Okay. Though this council also has deducted one third of the amount which was already deposited. Okay. So both the council are present at request of the council for GP for arbitration. Huh? You are representing GP for arbitration? Standing council. R2. Huh? Okay, both council.
Table number 10, Vidyasagar, Chief of the Administration.
Item number? Item number 10 and 11. Both are learned for arbitration, filing counters. GP for arbitration. GP for arbitration, are you going to file counter in IS?
We have to file count. There are several matters, Miller, not only three matters, two matters.
There are other matters connected
Other
with
matters
this.
are also there, Miller. Now all these 13 or 14 matters.
Please
are there.
furnish
All
those
these matters
numbers.
we have to-
Furnish those numbers so that we
Yes.
can list all
Yes.
the numbers together. 10, 11 and 12, Amma, last minute. Council on both sides represented that there are other 10 matters
We'll
that are
certificate
connected
them.
with these cases are pending. Therefore, this is direct. You furnish those numbers so that we can post all of them together. Post it for the time being. I'll adjourn to 23.
Yes.
Table 13, ABKS Prasad, Rajeswari Gadina.
I think the other day you have completed your arguments.
I think updating the Supreme Court judgment now.
Okay.
Our this is the last.
Item 13, 443. Yes. Hmm.
There is a violation of driving license.
Mm.
They are requested to pay and recover for owner. The recent judgment of Supreme Court on 30th October, the judgment of the HIGHCOURT versus Gita Devi judgment.
Yes, yes, I have.
There is when the driver having a willful breach of violation, they can recover from this
Owner.
owner.
Mm.
But in this case, the insurance company not proved,
Mm.
there is a willful breach of the driving. When PWT examined as a owner, he clearly denied that he is not having valid license.
Mm.
Last. Therefore, there is no willful breach of the in driving the prime vehicle. Moreover, the criminal case was not registered under Section MV Act. Therefore, there is no breach. Last paragraph. The judgment should be Supreme Court.
RTO is examined
Yes.
and driving license extract is also filed under Exhibit B2.
But in so that you kind of see in the paragraph 13, in class examination, RWP accepted that he is having valid driving license at the time of accident.
Opposite party 1 has contested the case. It's not which was valid. Okay.
16, 17, 18.
May please, ma'am.
Yes.
I will remove my last time. Let me pay the rents.
You are representing respondent number 2, huh? Sorry, 2, and you're the appellant.
The petition.
Let's.
Okay. Why GP for arbitration in this matter?
For Assistant Commissioner, I'm appearing for Assistant Commissioner of Endowment Tribunal.
Records వచ్చాయా? Received. LC records received. So both the counsel are ready with. Hmm. Hmm. Hmm.
If there have been notifications with the wrong,
Hmm.
for 18 months, you don't have any authority to occupy the property of the but liable to be declared as an enforcer. The tribunal has the right to declare and ask him to get it.
Hmm.
That's the only question by your watch. Well, in fact, the they are paying it to people for the patient. Has to be often and so that I get a better.
It is not for default of payment of rent. It's not default. It is for, see, as declare as an encroacher and also for evict. And the OA is allowed.
Yes.
Okay. Then you are ready with the arguments or not at all? Both counsel are present. As a last time, should get ready. Both counsel are present. At request of the counsel for the appellant posted to 2019 matter. 2111. Get ready on the day.
19, 20. Faruqi, Yural.
With the lordship's permission.
17, 18. 17, 18 only. All are connected. 20.
16, 17,
17 to 20 are connected.
16, 17, 18.
19 and 20 are different.
16, 17 are connected. 16, 17 and 18 correct.
16, 17, 18 are
Yes, ma'am.
connected. So all these matters together at on 2111. 16, 17, 18 any kalpandi. 21, no? Now 19 and 20. Counsel is available.
I appear for the review petitioner in 19 and 20.
Hmm.
Request for a week's time because I have my some personal engagements today.
Both counsel are present. At request of the counsel for the
Review petition.
a review petitioner posted to 2411.
Obliged, sir. Great. Obliged.
21.
21 is adjourned to 2911.
22.
While recently Wakana.
You are representing?
Appellant counsel, Kiran Reddy. Recently filed Wakala. Start.
What happened to the notice? Notice has been issued. Notice has been issued to the appellants. You are representing counsel Kiran Reddy Mallarapu. So, yeah, counsel is already on record. Why notice has been issued to the appellants? Because in the last occasion, Shailesh Garu is the counsel. On 29/23, in another court, not in before this court, Sri N. Shailesh, counsel has represented that there are no instructions from the parties. For that purpose, notice has been issued. After that, you have filed a wakalat or what?
No, my lords.
File wakalat.
You are representing the appellants. Then
Previous matter, we have filed our wakalat previously only.
you are representing?
Definitely.
No, actually, earlier, Mr. Sailesh is the counsel.
No, salary is fully.
It is on the proceeding sheet. Based on the proceeding sheet, I am saying in another court, Mr. N. Sailesh Reddy has represented that there are no instructions from the party. On that, notice has been issued to the appellants.
And the public approach for filing.
That is what you have filed wakalat. And now it is Sri Kiran Reddy Malarapu.
Yes.
Huh?
Yes.
So notice is all, but whereas sole appellant died and ochindi. That's the reason I'm asking. Sole appellant died.
Still approaching.
What to do? It is written like that. Anyway, counsel is already on record for the appellants.
I have filed my wakalat, the previous people. I will seek time also.
Okay, I adjourn the matter, but you are already on record. So the question of issuing notice again is not.
That is the power of that.
How many appellants are there?
Only one.
One appellant. As per the record, that sole appellant has died.
No, appellant is there now. Yes, no, the council who was appearing for the appellant, the previous council,
What is-
Ragmala expert.
The same number and choosing 123 of 19 only. 123 of 19. Rajamalla Reddy Garu died and Sri Kiran Reddy Mallarapu has filed wakalat. That is what you are already on record. And you are seeking adjournment, that's all. Okay.
Respondent.
Counsel for the appellant is present, respondent is also present. Counsel on both sides are present. At request of the counsel for the appellant posted to any tapul unna proceeding sheet anta. Posted to 24 level.
26.
Wait, please, Your Lordship. I am for respondent, my Lordship. My Lordship, on 28/2023, the appellant counsel has represented before this honorable court and said that the appellant is expired, my Lordship.
Hmm.
So you need to file LRs. By today, 3 months is completed, my Lordship.
Hmm.
So the case is abated, my Lordship. Sole appellant is expired, my Lordship.
Hmm.
LRs are not filed.
27/9/23.
My Lordship, 28/2023.
Learn counsel for filing necessary application to bring the allowance on record 27/9. This application is filed to condone delay of 7 days. Sole appellant died and she needs to bring the allowance on record. 28/23. 28/23. It is on 28/23.
Yes, my Lordship. 3 months has been finished.
And you are representing the respondent.
Respondent.
Counsel for the respondent is present. No representation for the appellant on call. Are taking steps to bring the LRs on record as a last chance posted to. $29.
Much obliged.
Lords, appeal for respondents, my lord, contesting respondents. The appeal is arising out of his dismissal of his suit for specific performance. Plaintiff is the appellant. My lord, pending suit, there was no injunction. Now he is seeking injunction, my lords.
Yes, the records received.
I filed the counter, my lords.
Counsel for the appellant is online.
So,
Sri M. Venkateswara.
last time also, yes.
Sri M. Venkateswara. No representation for the appellant on call. Counsel for respondent appeared through hybrid mode. Shall I post this as final hearing, sir? Why
Yes.
to put in?
Yes, that's better, my lords.
This
IA
is-
may be posted along with the appeal.
Yes. It's only a direction petition. This is directed to post this under the caption for final hearing.
The lordship may give some date, my lords.
Yes, giving date, sir. 30.
Oblige, my lords.
For the respondent.
IA 1 of 23, 2 of 23. Yes, both the council are ready.
I'm ready.
Yes,
I'm ready, ma'am.
you are ready. What about Surender? Already
It's already ordered, ma'am.
on 10/10/23. Permission is already accorded.
It has been.
And this also posted as final hearing. No, yes. Both council are present. This is directed to who's the AS, AS 82 of 23 as final hearing. Portable.
412.
26, if any marks.
Address is unclaimed, unclaimed deemed service. So yes.
Already said notices to the firehouse council.
Returned no such address for taking steps for service of notice. Yes, proof of service is also filed. Are you ready, sir? Next adjournments. Counsel for the appellant is present. At request. Posted to 6th December, 6/12.
I'm representing for appellant, my lordship.
Saroj Reddy. And who is the other side? Chaitanya.
Lord, I'm for the respondent number 3.
You are representing Chaitanya or Rajgopala?
I'm for the respondent.
Respondent number 2.
I'm 3 and 4, my lord.
3 and 4.
One has expired, 3 and 4 are elapsed. They were included in the suit itself.
It is already posted under the caption for final hearing. I do not know. Again, it came in interlocutory. Despite directions, it has been posted under the caption in interlocutory. No IS are pending.
They filed one IA and they withdrew that IA.
It is already ordered, no? No IS are pending. Council on both sides are present. Post this under the caption. Already direction on the Mavera court, but they have not posted as final hearing. Posted under the caption for final hearing on 6/12. 6/12.
Job license, my lordship.
Video number 28.
Why is there any urgency? 23 matter only, no?
No, Chelsea.
Okay.
I have filed for suspension.
Suspension petition. This other side council is available.
For filing counter.
I'm there, my lord. I'm filing my counter today.
Mm.
Lordship may take it up next week for argument. If otherwise, if my friend
You can get ready in the main appeal.
Matter. Man in personal property. The finding of the child code is absolutely necessary. Rather than matter, we let him give the contract. Rather than matter. You not sure. If it is required, then we.
My lord, there is a suit, counter suit. I succeeded in both the suits.
Hmm.
My friend did not have any interim order even at the state of trial court. So, my lord, the urgency, I don't understand suddenly what it has appeared.
Satisfy the court.
I'll argue the main appeal itself.
The court is appreciated the. Whether I am in person, admitted all the documents are. See, who's that? I am in person. They claim that they have purchased from me. But if they have to prove that so they are not filed suit. It is super information. I satisfied this court in regard to this.
Your lordship,
My friend
take it up next week. I'll argue.
saying that he is serving the counter.
No, sir, today it is filed today.
He served the counter so that
Already filed in the US, sir.
any short date will be.
Yes, for filing counter.
But
Counter is filed, my
he
lord.
is filing.
I already filed.
Just now he has given the copy.
Okay, I have to file in before the register.
USR number.
Before the register it has to.
I filed, my lord, already. USR number is 108. Even a filing.
Okay, I'll post it on 17/11.
Yes, my lord.
But
17/11 next week.
I'll get that.
29. He registered for a goal.
The appellant matter already admitted. Last time the position final review.
Oh, and the matters now is like jumbling. Whatever. It is an interlocutor only, not in admission also. It is already admitted, Andy. It's already admitted. And a call for the record. What happened to the records? Call for the LC records. We have not received, no? Await LC records. Already it has been posted for final hearing. What is happening is all these matters again posted in the interlocutory or in admissions. That's the problem. Anyway, it's already posted final hearing and await LC records. Both the counsel are present. Await LC records, which is directed to post the matter in final hearing under the caption for final hearing. Posted to LC records from Kottagudem. Okay, wait. I'll post it on 29/11.
May pass over, lordship, may kindly pass over. My senior is appearing for the response.
The papers.
Is it in IA 1 of 23, sir?
Yes, ma'am. I am seeking an
Injunction.
Pending this suit, there was an injunction. Failed disposal of this. The first appeals. And the suit is failed disposal of the suit. The same injunction will be granted.
No, lordship, that we are opposing seriously because the matter has been lordship
Have you
decided.
filed counter?
Lordship, may for the argument for tomorrow or day after tomorrow.
In IA?
Yes.
Okay. Okay, 9/11.
Obliged.
Both consular, please. IA 5 of 2005 and 1813. What is this? It is written as letter. Both consular there. Okay. 5 of 2005. Actually, we have allowed all these applications are already ordered. IA 1 of 19 is 514 days delay. It is allowed. 514 days. Then set aside the dismissal order is also allowed. Both these matters and it has been restored.
Yes.
Final hearing. Are you ready today or you? What is the CMA then? Workman compensation.
Yes,
Okay.
Yes, of that. Find us compensation of slave. But 4,37,900 about initially, but then a commission. Yeah. So the amount was not to call the debt to pay back. But that
Oh, penalty.
Total 6 lakh, but just 910. Those 2 orders, I tried to run the appeal. So the judge comes to. The interference law. But so the party. Subsequently, what has showed report that fund. For 200 from the new definitions. Entire amount is paid from the insured. Instead of the payment. Yes, payment, the check the various loss.
Before both respondent counsel is not here, your lordship can put it approved period. Meanwhile, I learn from both respondent.
Actually, in penalty, we have already decided few cases in favor of the insurance company regarding only penalty issue. I do not know about the other aspects. Oh, well.
2 weeks.
Okay. Counsel for the appellant and respondent are present. At request of the counsel for the respondent, forced it to 23 level.
28.
Why 28? You said only 2 weeks and again 28.
2 weeks.
This is their appeal. Let them get ready. 23. Amma, you're representing the respondent or the appellant? Appellant. Subhani. Counsel for the appellant is present, no representation for the respondent and call. At request of the 2006 matter, how many days will take? Notices, it's not the no representative respondent, learned counsel for the appellant short time to insist whether the list in the matter survives or not. Is it? How many adjournments will take, Amma? It is 2006 matter. Just to find out whether the cause survives or not, you are seeking. I'll do one thing. I'll put it under the caption for dismissal. Okay. 2006 matter. Enough time has been given. Even before this vote also. It is already dismissed earlier and you have filed a restoration petition that has been allowed and it is restored and again you are taking time. It will never end then. Notice from the court will finally for hearing the appellant finally posted to 15 level.
I have a petition. Morning, I requested for adjournment next week. There's a demise in sir's relative, so he attended the council.
I can't get you. What you said.
There's a demise in sir's families. So when they requested for adjournment, my lordship, I morning informed my lordship when called.
Council representing the appellant died and they got instructions.
We are ready, my lordship, but
continue
there's a demise due to demise.
And then Wakalat has been filed. Both counsel are present at request of the counsel for the appellant. Posted to 2007 matter.
Next week, my lordship, when it is. We are ready.
Arbitration Act. As a last chance posted to 1711.
Much obliged.
Item 34 and 35, my lord, your lordship may kindly have it after 10 days, my lord. Because senior wants to argue the matter on this matter. Today it's not possible.
How many adjournments you have taken, Prabhakar Garu?
Next week, your lordship may have it, my lord, any day. Certain.
Both counsel are present. Actually, in 35, we have not filed Wakalata. In 35. Because your name is not reflecting.
That was this week was our OP.
Ah,
That.
okay. Both counsel are present at request of the counsel for the appellant posted to.
17.
Okay. 17 line.
Achha, achha.
One minute. R1 unserved address not clear. R2 unserved address is left. ఒకసారి address verify check. No, in the last occasion, you said you'll file an application for substitute service.
Yeah, not.
Then you have taken time for that purpose.
Submit on merit, your marks.
Is there any section for you? It's final hearing. Sorry, address చూద్దాం. చూసి డేమెంట్ సర్వీస్ అడ్రస్ చూడండి పంపించిన అడ్రస్ 1 minute. R1 అడ్రస్ నెక్స్ట్
Number 12 that Subhash.
12-190 సుభాష్ నగర్ deemed services, because what the address which was mentioned in the application has been sent. So we'll treat it as deemed service only. But you have requested time for substitute service. It is on the proceeding sheet what to do.
House number is not mentioned. R2 is address. Here from the merits manager.
So you say that there are no merits in that.
Only
It is implied, isn't it? Okay. Case of negligence in injuries. Okay.
Arrestment of the WCA. Amount claimed to 5 lakhs murdered, amount transferred is 2,85,000 more to the nation.
మనం ఇది రాసుకోవాలి ఏం రాయాలంటే at this stage it is observed that the notices have been sent to the addresses mentioned in the application. Therefore they are deemed service అని చెప్పి రాసి అప్పుడు బికాస్ ఇక్కడ ఏం చేసామంటే ఫర్ సబ్స్టిట్యూట్ సర్వీస్ అని అనుకుంటాం. Yes.
It's a base of injuries. Primary involved the accident is a tractor and trailer. The applicant claims to be in laborer working in the tractor and trailer. And when he was traveling along with stone pillars, along with several other laborers. Due to the rapid negligent driving of the tractor, the tractor and trailer turned at the stone pillars beton. Subsequently, subject fracture issues. So that is explained. The contention, yes, in this matter, OP number one that is the owner of the should demand it fast. But the insurance company.
As many as 12 grounds. As many as 12 grounds.
This matter, the insurance company has issued a farmer's package policy. Finally, to tractor and trailer. But subsequent later, at the time of the accident, the trailer was carrying stone pillars. And secondly, when we have raised the from that matter, the no premium was paid to cover the risk of the laborers. No matter we have examined the our Subsequently, my lord, they have also examined an official of RTA. My lord, he stated that my lord, the crime vehicle is a non-transport vehicle. It is only used for agricultural purpose. No, my lord, the commissioner, without discussing all these aspects raised by the insurance company, my lord, only thoughts of the kindly my lord, for a moment, paragraph 22 of the order. But we have examined two witnesses, and we have excluded by D1 to D5. We have also examined official from RT. Now, my lord, the commissioner, paragraph 22. Careful reading of the FIR shows that one Chinchi Mandaya gave complaint to the police informing the occurrence of the accident, the involvement of the tractor in the accident, the involvement of the applicant as laborer of the tractor, the injury suffered by the applicant. The police received the complaint and registered an FIR and investigated. And after investigation, filed charge sheet before the judicial perfect magistrate at Sadnagar in STC 110/2008. In the charge sheet, the applicant was shown as witness number 3. Investigations of the police established that the applicant was the laborer who met with an accident while going by the insured tractor on 25/2007. Therefore, it is believed that the applicant met with an accident in the course of his employment as a laborer on the insured tractor and sustained injury. Well, thereafter, the commissioner, my lord, without dealing with the objections raised by the insurance company, went on to decide on the issue of the awarding compensation. The commissioner came to the conclusion that the injured was working as a laborer on the tractor trailer. Well, it has never discussed the points raised by the insurance company. One is that the crime vehicle is an agricultural farmer package policy. Secondly, my lord, no premium was paid to cover the risks of the laborer. But all these points were not discussed by the commissioner. At least the evidence, it has only extracted, my lord, the contentions raised by the insurance company, extracted the depositions of the witnesses executed by the insurance company, and have not decided the issue. My lord, all these things were proven by the insurance company, my lord. One thing is that it is a farmer's package policy, insurance policy. And secondly, my lord, no premium is paid to cover the risks of the laborers. But at the time of the accident, crime vehicle was carrying stone pillars. But only on the ground of sympathy, the commissioner went on awarding compensation, my lord. And even subsequently, the doctor, my lord, who treated the applicant, who issued the disability certificate, my lord, we stated that, my lord, the injured sustained 40% disability. The commissioner has taken 75% of the loss of the capacity, my lord, even if it is not scheduled. That is 23rd paragraph.
Why RTO is examined? Why RT authorities are examined?
It is a non-transport package for the 17th paragraph, my lord. The extract 17th paragraph of the order. Sri M. Ashok Kumar, son of M. Jogaya, senior assistant RPN Nandu was examined as Arthur Q. on behalf of the second half of the part. In his evidence, Arthur Q said that as per RC extract, the tractor so and so is a non-transport vehicle and trailer so and so is covered as non-transported agricultural vehicle. As such, it cannot be used as commercial vehicle. For the RC extract, heating capacity is only one. That is only for driver and no passengers can be allowed to travel in the tractor. If I extract of the RC, it is marked as which vehicle. Thereafter, commissioner created the issues. Based on the crime records, it came to the conclusion that my lord, the injured sustained the injuries during the course of employment and awarded the compensation. These aspects were not discussed by the commissioner. It is a very big case, my lord, to decide the honor because it's flat. Ground of the technical. Even remember the issue, where issue number 3, who are liable to pay the compensation? Twenty-four, 25. Paragraph 24, 25. The first opposite party is the registered owner of the vehicle as per the ask. The second opposite party is the insurer by insurance policy production. And the same is subsisting as on the date of the accident. We have not denied the insurance policy. We are admitting that the policy is taken. But, my lord, there are several violations that the concept of the policy. That is our main subject. But that is not even discussed by the council.
Record on that. See, that plea was not taken in the counter. See, where is the evidence that the labor are traveling in the vehicle along with the stone?
It's
It's not there. We do not have the record also.
We are not. They are permitted to read the narration. In the application, the applicant stated that worker has
Sir,
taken
count remedy.
first pair. In the application, the applicant stated that he worked as a laborer in the employment of the opposite party and the tractor trailer bearing stolen.
In order to unload the stone pillars at Kothur. At Kothur. Okay. Okay. But where is the denial by the insurance company in your counter? It's not denied. It is simply stated that there is a violation of policy control.
The second opposite party stated that they have been unnecessarily included even when there was no validity of contract. Stated that there is no employer and employee relationship between the first opposite parties. In the applicant was only practiced passenger traveling in vehicle in violation of the terms and conditions of the insurance policy. The driver was not having valid and effective driving license. Not able to take the pound. Very question that my lord.
How to see, though they have stated at least some denial. You have to deny that. See, they are carrying those stone pillars and other things. It's nothing is there. Simply stated regarding the license, and he's a gratuitous passenger and used for commercial purpose.
Is only meant for carrying because of food.
That is also, see, there is another judgment recently only we have disposed of, and that also the laborer carrying some stones. Stone pillars, they may be used for agriculture also, for making fencing and other things. Let me see your counter. Counter and the page index one. Opposite party page number 23. Working as a labor injuries, admitted applicant has Does not admit involved in the IRS acts injuries. Not taken. Not in the counter. Simply stated that they are traveling as unauthorized passengers. That's all.
It's a total mother which is a tractor and trailer.
No edit.
My
Charge sheet. Charge sheet page number. Darken. Charge sheet. As usually, I was just it's towards the back.
these documents, my lord, that the things of the it are admitted facts, but they need not be proved.
Ramasar Shishma. Complete this. Next.
37, then one question.
మోహన్ కృష్ణ గారు. CM, ఈ అపెలెంట్ ఎవరు కౌన్సిల్ నేమ్ ఇస్ నాట్ రిఫ్లెక్టింగ్. ఇది ఇన్సూరెన్స్ అప్పీలా? Rajamalla garu is no more. That is the reason we have issued notice to the appellants. But till today, notice is not served. Nalgonda. With 38. 38. Await task. Await service of notice. Posted to 23. 2311.
For the appellant, my lord.
Honor.
For the appellant, on behalf of Lakkadi Dayakar Reddy.
Are you ready?
Yes, my lord.
Okay. Yes, proceed.
My client Sheikh Asif was working as a cleaner, my lord, at the time of accident. Due to the accident, there was a fracture of right leg, fracture of skull, fracture of left hand, fracture of ribs, and multiple other grievous injuries, my lord. Initially, he was admitted to a government hospital in Nizamabad. Then he was moved to Usmania Hospital. Due to the accident, he was permanently disabled and was removed from his employment. At the time of accident, he was 19 years of age, my lord. As per the injury certificate and disability certificate, his age was confirmed as 19 years. But it was taken as 22 years while awarding the compensation, my lord. The compensation that was claimed was for 5 lakhs and awarded was 1,31,670, my lord. The salary was considered only as 1,792 rupees. And
see, no salary certificate is filed. Okay. No
Yes,
date
ma'am.
of birth certificate is filed. Okay. See, without any evidence, how can you expect the court to award lump sum amount?
Okay, my lord, but as per disability certificate, my lord, the
Disability was not taken into consideration?
it's considered, but 55% was only considered when disability certificate was provided for 60% and functional disability of 65%.
Disability to sustain 60% permanent and partial disability and earning capacity at 65%.
My lord, he was working as a cleaner, my lord. With a disability of 60%, he cannot continue with his employment, my lord. So in that case, the court has can consider 100% of disability, my lord.
The doctor was examined. Doctor himself has deposed that he has sustained only 60% and issued disability certificate based on the same. And the same was considered also. Earning capacity is reduced to 55%. That else. Okay.
Obliged, madam.
Okay. Yes.
60% is partial disability. Or functional disability is 65% is taken, my lord. It is very reasonable, my lord.
Signal has taken 60% disability. However, earning capacity has been reduced from 65 to 55. That
Okay.
Sushma, small case will dispose of.
Accomplished, my lord.
Counsel, are you available online?
Yes, my lord.
Yes. Your appeal is partly allowed. Amount has been enhanced from 1,30,909 to 1,54,800.
Obliged, my lord.
Next. ఇదేం సీఎంఏ ఇవ్వండి ఒకసారి చాలా నుంచి నా రిప్రజెంటేషన్ వస్తుంది. No representation on either side on call. And it's posted to 412. You are representing?
I'm for respondent.
Okay. How many? Okay. Both counsel are present. At request of the counsel for the appellant posted to 2411.
Present.
No representation for the appellant on call. The perusal of the proceeding discloses that there is no representation for the appellant. Even on 4/9/23, 21/9/23, 9/10/23. Therefore, as the case is of the year 2012, this case is posted under the caption for dismissal. Fall on 21/11. It's okay. So both of you are ready with the arguments?
Record is necessary in this matter. Record is
Both counsel are present. Register is directed to call for the record immediately from the concerned court. Posted to 28.
Yes.
Respondent counsel requested CASO report.
Both the matters, huh? B. Parmeshwar Reddy garu. In 44 also B. Parmeshwar Reddy. Jitendra. Okay. Okay. Next. Come. No representation as I said on call, hence posted to 30. No representation for the appellant. ఎన్ని ఉన్నాయి అవి? No representation for the appellant on call. Second time. Counsel for the respondent is present. Hence posted to 2211.
Please read the 46 and 47.
Yes. It's 3 months from the first 3 months. It's 3 months. Public library time.
46 and 47. Both counsel are present at request of the counsel for the appellant posted to. You need any record in this matter? You tell me. We will call for the records. At the time of argument only you are suggesting for record. Records available in these two matters. Shall we call for the records?
Here are the railway.
Shall we? Okay. Both counsel are present. Register is directed to call for the record from the concerned court immediately posted to
28.
28 level.
What's
48.
For the respondent claimant,
Agar any adjournments is correct.
48 and 50 should go together, my lord. Both arising out of the same accident. One is death of the driver, one is injury to the workman, another workman.
48 and 50. No representation for the appellant or counsel for the respondent is present. It's posted to 2111. Register is directed to put up both the cases together and
Together, your lordship.
the 50 and item number 48 and 50 as the matters are connected. As the matters arising out of the same incident. 2111.
Oblige.
Ready?
Insurance company, right? So the policy, insurance policy for one. He was working as a cashier in Arundel. I kind of tell you the page. See, copy in the page. It's called workman compensation general policy, right? Not on motor vehicle tax policy, right? But when kindly read that page, the right side, that right side, the policy enforcement. Now this policy witnesses that if at any time during the period of insurance, any employee in the insured's immediate service shall sustain personal injury by accident or disease arising out of in the course of his employment by the insured in the business, and if the insured shall be liable to pay compensation for such injury either under the insurance company will take indemnity. Here, the deceased died not in the bar and restaurant. He died in the outside due to the motorcycle accident. So it is the intention of the insurance company, right? It is not during the course of employment in the premises of the business. Right? Admittedly, the accident occurred due to motor vehicle accident. Right? Before the commissioner, the insurance company pleaded and also let the evidence available. Note so that your document kindly produce left side, and the premium also. The insurance company will collected for left side skilled labor 10 employees. Annual salary for 10 employees 3,60,000. That is every month per employee 3,000. 10 into 3,000, 3,60,000. But here the commissioner took the salary 5,000 and odd. That the insurance company is not liable. But my kindly tell you. Page 9, para 10, order. We have disputed wages and also employment also. It's not during the course of item catch. P. Sri Krishna was examined as order on behalf of the second opposite party. He filed an appeal in lieu of his chief examination, wherein he stated that he is working as the assistant manager in the second opposite party insurance company. As such, he is well acquainted with the facts of the case. He stated that the second opposite party has issued workmen's compensation general insurance policy bearing number in favor of Mr. Vijay Bharan and the policy is valid from 3/7/2009 to 2/7/2010. He stated that as per the terms and conditions of the policy, the second opposite party has indemnified the liability of 10 skilled laborers in case of a death and injury by accident or other disease during the course of their employment facing on proposal of subsequent wages. He stated that in the said proposal, the owner has clearly mentioned that the total wages of the 10 employees is 3,60,000 per year towards wages per annum, which comes to 3,000 per each employee per month, and basing on the said proposal after collecting exact premium, the second opposite party has issued insurance policy to cover the employees. He stated that as per the contents of the FIR charge sheet in crime number 217 of 2010 and 21/2/2010 at about 7 p.m. while the deceased was returning to his house from duty, he was hit by a motorcycle bearing number 12 and the deceased died on 21/2/2010 while undergoing treatment. He stated that the deceased did not died during the course of his employment while he was in the employment of bar and restaurant, but died due to involved with the above motorcycle. As such, the second opposing party is not liable to compensation, and the same is liable to the deceased for he filed office of the insurance policy. The same was not liable to. These are the facts. So let me kindly tell you at page 13, page 9 of the order, table 13, page 9. 21. The commissioner put the wages 5,478.50 paisa. The premium paid by the owner is merit for 3,000 rupees. But here the owner is liable. Only merit admits merit during the course of employment. The insurance company is liable only for 3,000. Accordingly, the award will come 2,76,255 instead of 5,04,488. I'm also relaying that the contention of the insurance company that it is not during the course of employment. After reading that, I can supply all 4 citations. The Honorable Supreme Court, 3 judges now. Employees State Insurance Act, Section 2A. Employment injury, notional extension arising out of and in the course of employment. Workman proceeding on a cycle to his place of employment when he was hit by a lorry and sustained injuries. Whether the injuries arose out of and in the course of employment to enable the workman to claim disablement benefit, and no causal connection between the accident and the work. The workman was doing at the factory established. This is the citation. Supreme Court 3 judges. What they just JR 2009 to take what 2008. Workman Compensation Act, Section 3 compensation accident arising out of the course of employment. Death of truck driver due to drowning. Accident taking place when the deceased after reaching a destination or sitting on steps of temple found no causal connection between death of driver and his employment. Neither employer nor insurer of vehicle able to take compensation. 1981 ACB 368 Workman Compensation Act, Section 3(1), Section 1. Accident arising out of and in the course of employment. Employer's liability for compensation. Workman employed as fitter who are going in during driving jeep, getting out of order. Driver asked workman to keep his hand on the carburetor to start the engine. Due to this fire, the clothes of workman started burning and he got burned. Subsequently, workman died. Whether the accident to the workman by putting his hand on carburetor was incidental to his work as fitter and it arose out of the employment, I lost. Workman Compensation Act 1920, Section 30 and 3 and Motor Vehicles Act 1988. The motor insurance, liability of insurance arising out of and in the course of employment. Death of driver while performing the duties as an employee and not as a driver. Accident occurred when driver after collecting rents from some third party as per directions of the owner of the vehicle was proceeding to meet him on his cycle. Whether the insurance company is liable, no, liability covers the driver only while engaged in driving the vehicle. Owner of the vehicle is liable to In this case, the purpose of giving the policy is only in the business premises. The accident occurred out of the business premises. It is not during the course of employment, and also wages also taken higher than the insurance as per the income.
The employment was proved blood. Not you can see the page 4, paragraph 8. In the cross-examination by the counsel for the applicants, RW1 accepted that this is the engineer was working in our bar and restaurant, and that the accident was occurred after completion of the duty while the deceased was proceeding towards his residence. So the accident was occurred during the course of employment. The owner was admitted. With regard to the policy, Lordship kindly see the page 5, paragraph 11. Paragraph 10, she said that earlier my friend was read. Sri Krishna was examined RW2 on behalf of the second opposite party. He filed an affidavit in lieu of chief examination where he said that he is working as a assistant so and so. Company as such, he is well acquainted with the facts of the case. He stated that second opposite party has issued workman compensation policy bearing number so and so for Vijaya Bar and Restaurant Malakpet, Hyderabad, and the policy was valid from 3/7/2009 to 2/7/2010. He stated that as per the terms of the conditions of the policy, second opposite party has indemnified the liability of the 10 skilled laborers in case of death or death injury by accident or in the disease during the course of employment. Whether the accident was occurred during the course of employment or not is a question. This was occurred in the course of employment while he is returning to his home. Lordship, kindly see the paragraph 11, RW2 in the cross-examination. RW2 accepted that as on the date of the accident, the policy was in force and policy was covers the risk of the 10 employees. He stated that he has gone through the policy records and accepted that after completion of duty hours while this was proceeding to home, decision made in accident. While returning home, the accident was occurred. He admitted that the policy covers 10 employees. He sums under the workman compensation policy. More, he is saying that salary with regard to the salary, he claimed 4 lakhs. The tribunal has taken into consideration minimum wage. You kindly see the page number 9. The applicant claimed that the deceased employee was being paid ₹4,000 per month as salary. The second offer contained that as per Exhibit B1, insurance policy covers the risk of 10 skilled workers. The total wage covered is 3,60,000, which amounts to 3,000 per month per worker, and therefore argued that liability as per the insurance policy to be restricted only to ₹3,000, no wage less than the statutory minimum rates of wages is permissible. Any agreement between any parties which is not in accordance with the public policy of paying minimum rate of wages cannot be taken into consideration. Therefore, the minimum rates of wages have to be paid and the amount of compensation has to be calculated only basing on the minimum wages rates. They have to, while taking the policy, they have to taking the minimum wage as per that policy has to, premium has to pay. It is also for the insurance company to verify the minimum rates of wages fixed by the government before issuing the policy, insurance policy as per GMS number 105, labor employment training, and basing on that policy, the tribunal has calculated the wages and granted the compensation. With regard to the whether is in this case not really notional extension will be applicable. With regard to that, I am relying on the judgment of Supreme Court 2024 ALD 38 with Supreme Court. Employees Compensation Act 19 Section 3 compensation. Doctrine of notional extension of employees premises has to include an area which workmen possess and repossess in going to and in leaving actual place of work. Application of scope. This is a driver of truck went to canal, fetch water, and also have a bath slipped into the canal and died. Act of this is driver truck in going to canal, fetch of water in a can for truck to ensure its safety and refresh himself by bath before he continued journey in heat of month as to be considered as incidental to employment by extension of notional employment theory, order of High Court holding that death occurred during the course of employment but did not arise out of the employment, therefore unsustainable. It's a para 11 and 13 will cover this head one. Only my submission is the beneficial legislation that notional extension has to take into consideration. Moreover, that Lordship kindly see the paragraph 9 that judgments. In the Manju Sarkar versus Mobisis Maya, 2014, 4 SSC, AR online, 2014. This is what driving of the employer from Agartala to Churibari FC Goda. When he reached near Dararam Nagar, he got down to make arrangements for repairing some mechanical problem in the truck when he was hit on the road by another vehicle and died in the hospital, applying the principle of notional income. Paragraph 12 minutes, also 11 Supreme Court in paragraph 11, 2017 6 ALD, so same thing has taken into notional extension. In another case, Leela Bai's case, paragraph 12, subpara 7, the class. It is evident that disease was present in the bus terminal and remained with the bus even after arriving from the indoor, not by choice, but compulsion is not necessary. In the another judgment, the Madras Division Bench. Fifth point, fight for consideration in this case whether the death of the employee while he was proceeding to work could be construed of the death caused in course of employment. Paragraph 7, the expression injury section under Section 3 Act has not been defined in that, but it's a wide import. Personal injury spoken so and so act may be leading to death or disablement or impairment of parts of the body and mind in either which event. The employer is liable to pay compensation if the conditions laid down Section 3(1) of the Act are observed. The three conditions for attracting the provision Section 3(1) of the Act: death or injury must be caused to a workman. The said injury must have been caused by accident, and the accident must arise out of and in the course of employment. It is well settled that if the injury or death from the point of view of workman who dies or suffers injury is unexpected or without design on his part, then the death or injury would be by accident, although it was brought about by heart attack or some other cause to be found in condition of workman himself. So finding as given, following the notional extension principle laid down by the paragraph 11, last page, question by construing the similar fact, the land judges of Madhya Pradesh High Court in so and so and so. The land judge of the Madhya Pradesh and so held that if an employee sustained injury death while he was proceeding to work, it should be construed as the accident occurred during the course of employment. In another judgment, High Court of Madhya Pradesh, This matter paragraph 7, same facts and circumstances. Learned counsel for the appellant also submitted that since the deceased had gone out his workplace, the employer would not be liable to pay compensation as the accident did not occur out of and in the course of his employment. However, it may be noted that the argument was not raised before the Commissioner for Workmen Comp. If the deceased workman was returning from the duty and the accident occurred while so returning, the accident would be treated as arising and out of his employment or in the course of employment. The contention about therefore cannot be accepted. It may also be noted that indisputably the accident occurred at Deepika barrier, which is one way from the workplace of the deceased workman to village Deepika. It has not been shown that the duration after the duty hours were over and the accident took place was so much that the deceased cannot be said to have been returning from duty, even if the deceased for some reason was detained for short time on way to his home after the duty, it would be not absolve the appellant employer from the liability to pay amount of the hour. So Millard, while he was returning duty, the accident was occurred and was died. So the accident was occurred during the course act and out of his employment. So at least notional extent should be applicable to this case. Millard.
Not overruled, 3 judges, there is a overruled than 2 judges. But the owner himself declared 3,000 only. But more than that, cannot be there. That's how much. Like 60,000.
The owner declared 3,000, we have received only premium.
They themselves admitted that their 3,60,000 has been taken into consideration by issuing a policy. Yes, nuts. 4,000 per. Even otherwise, the tribunal has to take into consideration by considering the minimum wage as on the prevailing of the accident. The owner admitted blood is entered into the witness box, admitted the accident,
And while taking policy, he himself declared 3,000.
before that
Get from the owner.
they have to verify while issuing the policy, they have to verify the minimum wage. At least out 10 members, they have taken 10 members.
Sir, it is the duty of the owner, sir. How much he is paying? He himself in the proposal, he said, I am paying 3,000. According. Yes. As per the policy. But he claims he is getting 4,000.
Replaced.
Yes, brother.
May I please?
Yes.
This appeal is filed by the insurance company. One is and the other is that the owner himself is the elder brother of the deceased. So in case of close relation, there should be a strong evidence to believe, though it is not barred under law. Those are the two main grounds. The claimants are the wife and children of the deceased. The deceased was the driver of DCM lorry bearing number AP28B 5971. Lordship may see the order copy, page number 2. They themselves stated, the applicant stated, fifth line, order. The applicant stated that the first opposite party is the elder brother of the deceased. And even though the first opposite party is elder brother of the deceased used to work as a paid driver on the above said DCM lorry of first opposite party. Then in para number 4 in the of the order at page number 3. In the counter, the first opposite party stated that he is the owner of the DCM lorry and that the deceased was his younger brother, and even though the deceased was his younger brother, the deceased has been working as a paid driver since a long time on his DCM lorry. My submission is, he is the owner, is the elder brother, is the driver, is the admitted fact. In such circumstances, there is I rely upon a judgment of the Supreme Court now. At page number 20, para 24. The case before Supreme Court is a matter between wife and husband. But there is a close relation. Anyhow, I will read para 24, 25. Which are relevant according to me. No documentary proof to establish the contents of employment was produced. No independent witness was examined even as to for what purpose the tractor was being used had not been disclosed. How the accident had taken place is also known, not borne out from the records of the case. If the deceased with all intent and purpose was the owner of the tractor, the claim petition of the 1988 Act might not have been maintainable. The petitioner 23 Act certainly would not lie, only because Section 143 and 167 and 1988 Act refer to the provisions of the 1923 Act. The same by itself would not mean that the provisions of the 1988 Act properio vigor would apply in regard to the proceedings for payment under 123 Act. The limited applicability of the provisions of 88 Act in relation to the proceedings under 23 Act has been discussed by this court in the aforementioned judgments. It is thus not possible to extend the scope and admit the provisions of the 88 Act to the provisions of 23 Act. The ingredients of the maintaining of the procedure under 1988 Act and 23 Act are different. The purpose for which the contract of insurance is entered into may be different. Where 88 Act, it will bear repetition to state. A contract of insurance would be mandatory for the purpose of application 23 Act. It will be optional and as indicated hereinafter. The so-and-so's case, even contents is permissible under the Act. The liability of the insurer is limited so-and-so. Lordship may say, para 22 is more relevant matter. It is, in our considered opinion, it is wholly absurd to suggest that the husband would be a workman of his wife in the absence of a specific contract. We have no doubt in our mind that for the purpose of proceedings under 23 Act, only the applicants have concocted the story of husband and wife living separately. If they have been living separately in view of certain disputes, the question of husband being a workman under her appears to be far-fetched one. So, there is no provision brother can be the workman, but in such close relation there should be some definite evidence like wage register, proof of wages, all these things. Mere statement that he is working under me is not enough to conclude that he was the workman. Second, of course, is on the question of driving license. Lordship may order pay and recover. That's all.
Explanation of part of the one for exam and problem set of page 6 not of examination by a case said that in the facts of the case said that case accepted that there was an accident on case no court and accident that sealed the way with the accident but still injury and died while he was driving the car for in while received the driving accepted that I saw here report reports table separating lungs except that there is no bar for the first of all other brother and the receiver of our accepted that about this how the light accepted that the was driving all the side of he accepted that they were not filed any City was not highway drive. And further, then the first of the party, the admissions by the insurance company. Yeah, to my commissioner that there is no bar to engage with brother. I didn't apply at this moment. The judgments are also recorded not. Which seven. That there is no bar. Citations not applicable. That's so here. Story. Case one they stated that they are being separate. And there is no documentary proof that you are engaged as driver. The vehicle. Here, it's up to what they find is the counter in our case. Page 3 now. The counter first of all part is stated that the counter is page 3 now paragraph. The first of all part is stated that the counter will be same with our see the ones in the you want over the Asia and different that used to pay wages to see on or with other drivers engaged by owners, the employers of other lorries. If for the first of all, what is that means that the first of all, concern with the body of the employer side, but yeah, first of all, same but I think the attempts of the action. So here we have to first of all, current how much admitting the employment age. My time should not done. In fact, admitted by the contesting part of the person, he not be go the best. My son should not have in the petitioner since the say they were died was the applicants are just compensation and the sales company like to receive compensation then policy for driving like driver drivers was award. Yes. The driving basis is concerned not the admitted fact that the disabled driving cyclists would drive the NUD. So their context of that you do not have the entire of the past. So once you have if a person having license driving light motor vehicle, right, both is permitted to drive both and then transport and non-transport. That not what is good to us. And that should not so like it. People also is not better since they are not, there is no substantial law. Which is self allowed commissioner except the 12 findings.
Employee relationship is a question of law. Whether he is a workman, whether he was under the zone, whether that is the employer, whether he is a workman or not is a question of law. Section 2N of the WC Act, whether he comes under the definition of workman or not is the question of law.
May it please your ladyship. May it please your ladyship.
Are you able to hear me?
Your ladyship. Your ladyship, in serial number 52, I beg to appear for the appellant Madhiraju Prabhakar Rao, your lord.
52, huh?
Yes, your lady.
52 and 53 are adjourned already. Adjourned to 1711 in the morning itself.
Indeed, your lord. Okay.
Okay. Now we are in 54. TL Krishna Prasad and Anjali Agarwal. In the morning, I think Anjali has appeared and requested time. No representation for the appellant and full counsel for the respondent appeared through hybrid mode and requested time, and it's posted to 2023 11. This next.
I appear for the respondents in this matter, Your Lordship. We have only received this morning the wakalat.
Which one?
55, item number
55. Have you filed wakalat?
No, Your Lordship. Today morning we have received, we filed wakalat, Your Lordship.
You say you are appearing for respondent, but it is just now.
My apologies for that. I
Your
take
Lordship,
notice for the respondents.
I'm with the appellant, Your Lordship. That's what we wanted to inquire whether the notice has been served upon the respondent.
Notice is served and they are ready to file wakalat also, madam. 50, item number 50.
55, Your Lordship.
55, sorry. 55. Counsel for the appellant appeared through hybrid mode. And your good name?
Rohit Pogla, I take notice on that.
Rohit so-and-so submitted that, stated that he is going to file wakalat. Intent to file wakalat on behalf of the respondents. Hence, at request posted to when are you going to file wakalat?
Tomorrow morning we'll file, Your Lordship. It may take up to 2 weeks. Subject to convenience, Lordships.
Then I'll adjourn directly to 2 weeks. Why again?
Very
2011. 2011.
Very
File wakalat also in the meantime.
Very well.
Yes, next.
Obliged.
I'm visiting what's the petition now.
Mm.
Document how this matter will be divided because I'm waiting for lower court to call.
Record వచ్చిందా? We have received the record.
Only on Friday because they're waiting for the CD file to come.
Okay, 10-11. Counsel for the appellant is both counsel are present. Posted to at request of the counsel for the appellant posted to 10-11.
57 says Pramod Gaur,
appellant.
You are ready? Both of you are ready or?
Yes, yes.
The case was rejected on negative 2 issues.
Pramod garu.
Was not a bona fide passenger, as well as the incident was
Listen, Pramod garu. We have only 5 minutes time. Can we complete that within 5 minutes? No, at 2:30.
Yes. Yes.
5 minutes at long.
So that. After that.
It's already time is next. Pass out Jada. And another one is Nageshwar garu.
60. Item 62 inform order.
Item number
62.
62. In the morning, I think you have represented. Someone has. Your colleague has represented. You are representing the appellant now. J.R. Manohar Rao garu is available online. No. Counsel for the. No representation for the counsel for the respondent. Counsel for the appellant is present. At request of the counsel for the appellant posted to. Shall I post it for the first week next month? There's no urgency, no. Posted to 5/12. 5/12. Yes.
Item 61, Your Lordship.
Item number 61. Geeta Madhuri.
10th, Your Lord. Lordship, my hand. Safe.
Who is asking adjournment? Who is you're seeking?
I'm with counsel for petitions, but I'm for the respondent. Item
You're
60.
seeking adjournment, Amma?
Yes.
Both counsel are present at request of the counsel for the respondent.
10.
61. Posted to 10/11.
Ladies, item number 73.
I appear for the petitioner.
It may be taken after the lunch, ladies.
73, my lords, I'll only explain the reason today for two reasons, my lords. One, my lords, matter there was a document related issue, my lord, and an FI and a criminal complaint has been registered for an order of the Metropolitan Magistrate. We have filed an IA bringing the document on record. The order was only available last week. So we filed that IA, my lord, to bring that order of the Metropolitan Magistrate, which is important to the dispute. Second, my lord, there's some difficulty for the senior counsel today. My lord, it on Thursday or Friday, my lord, just to my lord's convenience. I'm not taking a long day. With an interim order in my favor, I'm only asking for Thursday or Friday, only for one simple reason, because that IA has been filed today. I have a paid copy also. My lord, get a copy of the IA.
So they have already taken 2 many adjournment. No further adjournment can be taken. And secondly, what they are talking about the document, it has nothing to do with the matter. I will explain in detail. It will take only 5 minutes, and I will explain how it is irrelevant for the case. It will be taken by 2:30. No, it is not required at all, ladies. Ladies, they are telling they are.
The Metropolitan Magistrate, my lord, 16th October, my lord, when did we receive it, my lord? My document petition is there, my lord. The document petition has been filed, my lord, part of an affidavit, my lord. IA, today it was filed today, my lord, because we only got the certified copy of. Not on the record, my lord, we filed it, which is why I'm just giving a fair copy only for my lord's perusal, my lord, to show that this was really on our part. Yes, ma'am.
Ladies, may hear the matter at 2:30 after the lunch.
I will.
या तो ये लिखा होगा कि या तो लिखा होगा तीसरा जो लिखा हो सकता है कि इन्वेस्टिगेशन ऑफिसर आया था फाइनल में हम देखो सही जान है उनका आई वाला होता है हमारा इकोनॉमी का हमारे डिस्कनेक्ट हो गया नहीं यार 15 सेकंड तो बाकी हाँ वो क्या क्या कर सकते हैं सीनियर को भी लेके जा रहे हैं because of the pressure of the senior he could not pass the order for 3 years near to over here नहीं नहीं मैं तो ऑनलाइन मेरे को ऐसे देखी थी क्या है actually दोनों में क्या करना होगा इस बहुत है इसी करते हैं Hello. Bye bye. Very good operation. How are you? Because I had laptop. And I only one item was there. Yes, yes. Ah. 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 Okay. Ah. Okay. Mhm. Mm. Mm. Yes. 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 Ah. I know. I know. Ah. ठीक है. Okay. Okay. I know. I know. ठीक है. क्या करेंगे? No, give me like that. Let me know what's your serious. Want me to leave that? You can decide. I know. I know. I will do that. Yes. Yes. Sir. Tomorrow also. Yes. Mhm. Yes. Yes. So you judgments with that, right? Different, right? So it's not one that will work proceedings. There's no provision of powers. Now, once the proposition from these and search again came across the notifications to this case. So I think that I can use like a object put the actually to it. So only one paragraph.
Hmm. Who is the other side? Both council are present. Both council are present. Request of the council for the. Well, it is 23 matter, no? 412. 412, no? In the meantime, list is directed to call for the records from the concern. Hmm.
43, give permission for all. Jitendra.
Adjourn to 1511.
Promote board. The case of the central bureau may choose the issue number 2 and 3 that exceeded whether the district was a bona fide extent and the incident was an untoward incident. So the by negating these two, they claim that in spite of the district was holding daily tickets and also apart from that, these two things are admitted. But it's now I invite your last sign at the so the system number 2 and 3. These two districts were held together by the signal below. In the phase 6. 6 phase 3. Phase 3. Number 2 and 3 were taken together.
Yes. Yeah, got it.
The case of the is that their mother, the deceased of Kotaka, while traveling from Seva to on 10/6/2008, with a well genetic had an accidental fall at a destination that is Nagar and died due to multiple injuries on the spot. Admittedly, none of the applicants had personal knowledge of the purchase of genetic by the deceased or the manner of occurrence since none of them was accompanying her during the fact. In the cross-examination, AWP1 first applicant admitted that she does not know in which train the deceased traveled and whether she purchased any journey ticket or not. She also admitted that her mother was traveling alone. She also does not know whether the Kerala Express would have stopped at Tripura. According to the applicants, they came, so it is very clear that the applicants are not the witnesses. They are not the companions, they are not the witnesses. So the ticket was recovered from the deceased at the time of inquest. According to the applicants, they came to know about the accident subsequently through newspaper publication and then they approached the police and identified the dead body at the time of postmortem examination. Admittedly, none of them was present at the time of inquest. This is again important. The inquest report exhibit A2 also shows that the inquest was held over an unidentified. So, the dead body inquest was held on an unidentified dead body, and the ticket is recovered. The only ground is that the ticket held by the deceased was for 2 persons, issued at Sevagram in Maharashtra, and the destination station is that is of Sirpur Kagandar. That is in Adilabad. I'll try to do that. In the inquest report exhibit A2, which is further recorded that while the train was proceeding through Sirpur Kagandar slowly on the down loop line, the deceased tried to get down from the running train and slipped and fell down. Exhibit R1 Division Railway report shows that the train 2626 Airline Express had no stop at Sirpur Kagandar railway station and journey ticket was found with the deceased was not valid for the train number so. Based on the investigation made by the Railway Protection Force, it is concluded in the digital railway manager's report that the deceased mistakenly boarded. mistakenly boarded general compartment of Kerala Express at Sevagram railway station, and while the train, when the train was passing slowly to down loop line at Sirpur Nagar, the deceased tried to get down from the moving train and had fallen down. It is significant to note that the deceased is a resident of Sirpur Nagar, even according to the applicant, she was returning to Sirpur Nagar from Sevagram. That the deceased had a fall from Kerala Express is admitted in the this is important. Regional Railway Maintenance Report, Exhibit R1 also. According to the applicant, the deceased accidentally slipped and fell down from the train. Yet Sirpur is not specified by them either in the application or in the evidence as to why and under what circumstances the deceased had to come to the door of the compartment and how she slipped and fell down from the down when the train was not having any technical accident. So the document in the above parasimilar, they are not they are not the passengers. Co-passengers are the persons traveling with them. Therefore, when the person of saying whether how she traveled, how she fell down, all this is speculative. So it is not the case of the applicant that there was any heavy rush. How they can also say that heavy rush of passengers are which are thrust from passengers from inside the coach, or that there was any jerk, severe jerk or jolt that triggered the fall. On the other hand, after due investigation, it is concluded that Division Railway Maintenance Report Exhibit R1 and also Railway Protection Force Inspector's Report, which is enclosed here too, that because the train was not having a scheduled halt and the deceased had to get down at the destination, that is Sirpur Nagar, she tried to deboard from the running train which was going slowly on the down loop line, and in that process she slipped and fell down. Since the deceased is the resident of Sirpur and her destination was also Sirpur Nagar, it is possible that on realizing that the train had no halt at that station, she tried to deboard from the moving train, which was going slowly while crossing through the station, and in that process it fell down. In the brief particulars of the untoward incident in form number 2 and also in form number 1, which was enclosed to the decision report, the cause of death is noted as getting down from running train, so on. So all these documents prepared subsequent to no witnesses. Now I invite you to stand attention to DRL report that which was enclosed with the report that. So places to see this because I have highlighted them because instead of perusing it, those highlighted parts you will have to go through. It could be with the FDS in para accidental injury and death case like this, the swap page. After WS, yes, that is the yes. Yes. Timing incident. Column 11. Timing. The EO has started thorough inquiries into the subject's case, which revealed that on receipt of memo 3, Rathod Mohan HC so-and-so along with GRP so-and-so, Rajeshwar Rao attended the spot and noticed one woman aged about 50 years having head injury. The GRP HC so-and-so searched the deceased female and found traveling ticket number so-and-so, adults 2, value 110, X Sevagram to Sirpur, ticket issued on so-and-so. The question is this: the other person who was traveling with her is not, because admittedly the applicants are not applicants who are not the passengers. Who is the other person is not. Maybe Millard for any reason at the last moment, supposing a person wanted to travel along with her, might have been changed. Changed his mind and might have been stopped also. We don't know. All this speculative. Millard, because the other person who was not traveling along with the disease was not known. Therefore, the disease is the journey is invalid. That's what the signal is. Millard, for a moment, Millard assuming that if a person is assuming a match, person is 2 tickets for a moment. How the railway is going to lose traveling with 2 tickets, traveling 1 person? It is not a case without ticket. So the bona fide is ruled out. My rest of the submission is that the DC was the bona fide journey of the disease is ruled out. In fact, it is a double bona fide. So, Millard, And follow the decision was an aged lady, aged more than 50. Says, attempting to get down from that running train is also not supported by any evidence. Moreover, the person who has given the message was not examined. And that is supposing there is two interpretations are possible as per the Vijay Kumar Prabhakaran. Either she could have been attempted to get down from the train, or she could have been fallen down accidentally also. Assuming for a moment if that was not that station was not destination station of the deceased, the imagination could be different also. That means she because that is destination station, she might have tried to get down from the running train. Also, she might have fallen down from the train also. She might have come to the door point. There is no doubt about it. So, in the process of thinking of whether to get down or not, in that process also she could have fallen. So, when two interpretations are possible, the interpretation which is in favor of the claimant, which I invite you not to stand attention to next in the same particular. Next paragraph. That is the first para 11, para number 11, subpara 1, and then also 5. ASI TF. Sipur called inquiries in this case on 22/9/2009. He met with the TSHC Bhikshapaya, who was performed on duty so and so, and obtained a statement. He stated in his statement that he has given a memo to IPF Sipur Kaganagar and GRP Kaganagar through DTSS auto regarding one unknown female person fallen down. The initial message was fallen down from the train. Fallen down from train number 2 express lost on platform number 2. This is the very information. It's fallen down from the train. It is not that while getting down fall. The message does not say that while getting down she has fallen. On inquiry, next minute, bottom paragraph. On inquiry, the deceased person by mistakenly boarded in the general coach of Kerala Express at the Sevagram railway station and the said train passing through slowly on down rope line platform number 2. Same time, the deceased person tried to get down on the platform and fallen down indoors. This one. So now, and all the documents enclosed to it, the inquiry reports. Insofar as the disease is concerned, they themselves say the disease. She was a complaint. Everywhere they were mentioned, and no one was examined by them except DRM report. Whatever the DRM report said, the report below accepted and below that the disease tried to deboard from running train, and it amounts to self-inflicted injury. And there consequently, the claimant is not entered. That is what the court says. Well, now I invite you not to stand attention. So, in this case, no one was examined. Whereas in case of that is Vijay Prabhakaran, in this case, No doubt it is possible that two interpretations can be given to the expression accidental falling of a passenger from a train carrying passengers. The first being that it only applies when a person has actually got inside the train and thereafter falls down from the train. While the second being that it includes a situation where a person is trying to board the train and falls down while trying to do so. So the corollary of it, that here it is a case where while boarding the incident happened. In my case, with the corollary while getting down, assuming for a moment when an incident while boarding a running train is untoward, then the corollary of it that while getting down from running train should also be an untoward. And moreover, in this case, I invite you not to stand and to para 8 minute paragraph 8 of this segment. However, the evidence of BW1D, Satyan, who was the station master at the railway station, corroborates the evidence of BW2. BW1 adds deposed that he saw one girl running towards the train and trying to enter the train and she fell down. He has further stated that the deceased Abja had attempted to board the train and fell down from running train. For this reason, the tribunal held that this was not an untoward incident within the meaning of the expression in section 123C of the Railways Act, as if it was not an accidental falling of passenger from a train carrying passengers. In appeal, the Kerala High Court was of the view that the deceased sustained injuries, even according to the respondents, are an anxiety to get into the plane which was moving. Hence, the High Court held that the deceased came within the expression actual falling of a passenger from a train carrying passenger, which is an untoward incident, as defined in section 4. So, my respectable submission is that even assuming that in my case also, the deceased attempted to get out from running train, still the incident is an untoward incident only. And moreover, the respondent has not, unless until the incident is proved under one of the exceptions, A to E under 124A, the railways have no case at all. Because the exceptions are carved out under section 124A are like this. I read up because we are not very well aware in spite of that. See, Millard, under 124A, suicide or attempted suicide by him, self-inflicted injury, his own criminal act, any act committed by him in a state of intoxication or insanity, any natural cause or disease or medical or surgical treatment unless such treatment becomes necessary due to injury caused by said untoward incident. These are the exceptions provided under 124. None of them are told. Simply saying that because she attempted to get out from running train, that amounts to self-inflicted. Now, for that, Millard, I invite you to stand attention to Millard. What is self-inflicted injury is being defined by this honorable by Lordship's endorsement. Long ago. For that, what are the requirements categorically mentioned? The expression immediate. The expression self-inflicted injury is not described or defined under the Act. However, it is not difficult to understand its scope. The infliction of the injury should be by the person himself upon his body and out of his own volition. It presupposes the state of mind wherein the person accused of it has conceived an idea of inflicting an injury to himself. This in turn presupposes the person being in a state of mind to take an independent decision. When these aspects are established in relation to your person while traveling in a train, the railways cannot held responsible to fail. So these are to be proved. Supposing simply saying that self-inflicted injury is not suffice. Why he has inflicted injury, all this have to be proved by the expert. Unless that is proved, the injury cannot be termed as self-inflicted injury. It is only an accidental injury. If you also inform Millard, there is a recent video is there. Millard, that video is not for this purpose. In Karnataka, one person was says whether it's correct or not. He voted for Congress. Now he says that the Congress is not doing well. Therefore, the finger which finger I have voted for, that he cut it deliberately. So see, he has a preconceived what the Nasrani said is clearly addressed. He has a preconceived mind because he done a mistake. He realized he wanted to cut the finger which he voted for, the finger which was used for voting. So my response is that because if it is to be termed as self-inflicted injury, these have to be proved. Therefore, my submission is that nothing is proved by the respondent. No one was examined, and simply saying that the injury because she made an attempt to get out from a running train, it is a self-inflicted injury, and therefore, and the ticket held by the disease was not for one person but for two persons. Therefore, neither she was a bona fide passenger nor an incident in an antibody incident. Therefore, consequently, so my submission is that nothing is proved these two things, and no exception is proved. Holding two tickets and traveling one person can never be termed as not a bona fide passenger. Maybe Millard for different reasons at the last moment, even may also be a cause due to ignorance also, the other person could not have been cancelled. Moreover, ticket is a common ticket, that is computer's ticket. Maybe they know, see, and this was a rustic villager, illiterate rustic villager who don't know anything. Therefore, these are so many questions would arise. Therefore, the respondent did not do anything.
to say that the disease was not a bona fide passenger, and also the incident is not a bona fide, not an untoward incident, attracting the one of the exceptions to 148. Therefore, it is a clear case of untoward incident, and the decision was a bona fide passenger. Therefore, the claimants are rated. Listen.
Relying on the express, I think roughly time to the exit payment. Almost the dates. Later, 15
Page number, expected. 20?
It is 16.
Hmm.
Summary.
About FIR, ma? Expected one? FIR column number 8 is the reason for delay.
It is 16 because of already fine. Actually, finding the column 8 is that's subject ticket. Having invalid ticket number shown starters to value rupees 110 x with silver gram to 60 hours. And also watching the time is impressive. Column number 9. Karanam kalvitaku 5 example karanam.
Yes.
ఏది 16 ఉన్న సేవాగ్రామం నుండి సిక్కు సారజనకు టికెట్ తీసుకుని కేరళ ఎక్స్ప్రెస్ నుండి ప్రయాణిస్తూ సిక్కు కాకినాడ రైల్వే స్టేషన్ బట్టి డౌన్ లూప్ లైన్ ద్వారా ట్రైన్ స్లోగా వెళ్ళిపోగా అట్టి రన్నింగ్ ట్రైన్ నుండి దిగుటకు ప్రయత్నించగా అట్టి బండి నుండి జారి తలకు బండిని కాల్చింది. And also locking the time is the evidence of it that the one I was not last legs. I was not covering during the have identified my mother at the time of postmortem ecology. I failed to know regarding the death of my mother through paper. Also, like the time to second. Applicant number 1. On the date of death of my mother, I was residing with my husband in his family. My father died 4 years prior to my mother's death. I have not produced the death certificate of my mother. My deceased mother granted is to my sister at Sevagram, and I do not know in which train she traveled and whether she purchased the ticket or not, and also from which train she has fallen down. We have received the ticket from the police. My mother traveled alone. I do not know whether TSHIGHCOURT stops with father's matter. I came to know about the death of my mother through newspaper. My neighbors informed me. I was not present at the time of the test. And also largely thanks to the judgment of the paragraph 8. Paragraph 8. In the process of reaching data one, he admitted that he doesn't know in which train Darcy traveled, whether she purchased any journey ticket or not. She also admitted that her mother was traveling alone. She also does not know whether the Kerala Express which stopped at Sittu Kakinada or not. According to the applicants, they came to know about the accident subsequently through newspaper publication, and then they approached the police and identified the dead body at the time of post-mortem examinations. Admittedly, none of them were present at the time of the test. The inquest report existed also shows that the inquest was held over an unidentified dead body. In the inquest report, Exhibit A2, it is further recorded that while the crime was proceeding to Nagar, slowly on the down roof line, the deceased tried to get down from the running train and slipped and fell down. Exhibit R1 Regional Railway Manager's report shows that the train number 2626 Kerala Express had no stop at Nagar railway station, and journey ticket which was found with the receipt was not valid for the said train 2626 down Kerala Express. Based on investigation made by the Revenue Protection Force, it is concluded in the Regional Railway Manager's report that the deceased mistakenly boarded general compartment of Kerala Express at Sevagram railway station, and while the said train was passing slowly through town loop line at Nagar, the deceased tried to get down from the moving train and had fallen down. It is significant to note that the deceased is the resident of Nagar, and even according to the applicant, she was returned to Nagar from Sevagram. That the deceased had a fall from Kerala Express is admitted in the Regional Railway Manager's report, taken to R1 also. According to the applicant, the deceased accidentally slipped and fell down from the train at Nagar railway station. It is not specified by them either in the application or in the evidence as to why and under what circumstances the deceased had come to the door of the compartment and how she slipped and fell down when the train was not having any scheduled halt at Nagar. It is not the case of the applicants that there was any heavy rush of passengers or push or thrust from passengers from inside the coach, or that there was any severe jerk or jerk that triggered the fall. On the other hand, after due investigation, it is concluded in the Regional Railway Manager's report Exhibit R1 and also the Railway Protection Force Inspector's report, which included that because the train was not having scheduled halt and the deceased had to get down at her destination, therefore Nagar. She tried to deboard it from the running train, which was going slowly on the downhill line, and in that process, she slipped and fell down. Since the deceased is resident of Nagar and her destination was also Nagar, it is possible that on realizing that the train had no halt at that station, she tried to deboard from the moving train, which was going slowly, by passing through the station and in the process she fell down. The in Form 2 and also in Form 1, which are enclosed to the Regional Railway Manager's report, the cause of action is noted as getting down from running train 2626 Kerala Express. Though it indicated that the deceased was having journey ticket, the same was not valid for travel by train number 2626 down Kerala Express, since there was no stop for the train at Nagar railway station. Under Section 124A of the Railways Act, the dependents of the deceased person would be entitled to claim compensation provided the deceased would have gone for the passenger. And the death was due to an untoward incident, which is especially denied in Section 123C, including the case of accident fall. Though the expression accident fall is not further defined, in its natural sense and perspective, it would be a fall that occurred accidentally without the volition of the victim or for reasons beyond his or her control. When a fall occurs due to an intended or deliberate act of the individual who indulges in such an act with full knowledge but unmindful of the consequences and taking upon himself or herself a huge which involves therein and perpetrates such an act with carelessness and recklessness. The same does not qualify to be termed as an accidental one. On the other hand, such conduct will amount to criminal negligence. And also largely times to 13 paragraphs. In the present case also, the conduct of the deceased please an aged lady in indulging to get down from the running train at Nagar railway station, where the train had no scheduled halt, clearly shows that she was bent upon to get down since it was her destination and also place of residence. Unmindful of her advanced age and the extent of risk adopted and the consequences entailed, such conduct clearly amounts to criminal negligence, and the injuries resulting therefrom are clearly self-inflicted. Such conduct cannot be termed as ordinary negligence. We will assume for a moment that between boarded a wrong train, therefore Kerala Express, not knowing that train, that the train had no halt at Nagar. Even then, when she found that the train was not having halt at the station, she ought to have continued the journey till the next halt but not to resort to devote from the moving train, engaging the client. Though the process contained in section 124 of the Railway Act are beneficial in nature, they are meant to serve the interest of the victim of genuine victims of an untoward incident, but not to benefit the kith and kin of those passengers who indulge in misadventure and abductive attempts to both are devote that ultimately proves fatal. The compensation paid from the public exchequer is not meant to compensate for the mistakes of the passengers who do not abide by the law. In the present case, the conduct of the deceased in trying to devote from a running train at Sikkur Kavinada station, where there was no halt for the trial. It is severely the misdeed or disadvantage and adoptive attempts made by the deceased unmindful of the consequences. The injuries resulting therefrom are therefore clearly self-inflicted, for which the responding trial cannot be held lightly. In the circumstances, it is held that Betsy did not show to be one for a passenger of crime, 2626 down TSHC, and the death of this is not due to an. My congratulations to Lord, first of all. As for the AW's responsibility, Lordship, she admitted clearly that her mother was traveling alone. And also they stated this that she is having 3 tickets. But the tickets were invalid tickets, Lord. The Kerala Express has no stop to the Lordship. From the running train, Lordship, she get down. My contention, Lordship, she is not a bona fide passenger of that train. And also in this report also clearly stated, Lordship, she is in the running side, Lordship, she get down. Particularly that Kerala Express has no scheduled stop, Lord. And also there is no eyewitness which purchased a ticket or not. High condition will that two invalid ticket also planted once.
Yes.
Even as for the judgment of the Supreme Court also, Lord, they have not filed any affidavit she purchased the ticket or not. But they are not they don't know about the purchase the ticket or not. They have clearly stated there is no eyewitness to purchase the ticket. Even invalid ticket also. Even invalid ticket also, there is no eyewitness. In the affidavit also, they have clearly stated that the incident of this incident, they know in the newspapers. There is no eyewitness. She purchased invalid ticket also. There is no eyewitness. There is no affidavit filed by the petitioners. And also, she voted the wrong train.
All these are admitted facts. They mention that by mistake.
Yes, to get a wrong.
But what they say is that by mistake she got it. By mistake. So where any by mistake is not intended or intentional. See, boarding as well as even arriving from the train also by mistake. So according to them, she boarded by mistake the Sevagram Kerala Express. So therefore, whether the ticket is recovered from the deceased, and in so far as the validity is concerned, I would like to give an illustration. Validity refers to time, not money. Value and validity are two different. Suppose, tomorrow, today, supposing a person holds a ticket of this date, full value, and he or she wants to travel tomorrow with the same ticket of which is having full value. It is not valid because time expired. By effects of time, the time expired. So the value remains the same. Validity has gone. So by that validity refers to time, not money. So tickets are valid. So if it is that if the biggest value is under value, it can be validated. More or less, the disease is traveling more than 200 kilometers. Sevagram is in Maharashtra. Sirpur Kagal in Hyderabad, more than 200 kilometers. Certainly, she was allowed to travel for.
Even though the tickets are valid, but the tickets are not valid for this trial.
So, then the bona fide is admitted in the document. In the DRA report, the disease was a bona fide patient that is admitted. It is not in dispute. And the fall is only point is that whether the incident is the untoward incident or not. That is the main crucial question. So my responsible submission in this regard, I have already Vijay Kumar Prabhakar clearly held, though there was evidence that the disease was there is an evidence from the railways that the disease was trying to board a running train. Therefore, here the choreograph it. So deboarding from a running train. So when that is an untoward, this is should also be untoward. Therefore, the incident as well as and moreover, the respondent has not told any except the except is carved out under 1.4. And moreover, the complainant who gave message was not exempt. And his evidence, his statement is that she has simply state like Mr. You have no, we are also depending on the same, your document only. We are not having. You are also be kindly, but yeah, yes, please. Yes, we only still there, still highlighted. So it is simply what this is. It is there in the record, but still highlighted this.
You have not gone through the inquest report. All the witnesses are railway people only.
Yes, ma'am.
From second, third, fourth, there are railway people. They opine that the person has fallen down from the runners. You have not stated that.
No, I have stated fallen down from the train. That's my reason.
Witnesses are important. Witnesses are railway people.
No, Milad, I have stated in the.
And also, while searching, they found the railway ticket, journey ticket from the possession of the deceased.
You'll ask me kindly. I have it is my reading. You'll ask me kindly. I have answered.
I have gone through.
So now the evidence out of that.
Main evidence.
What has happened in this matter, the reason I'm asking for Thursday or Friday, my lord, is only for only one limited permission, my lord. Because of an idea, if it files for permission, to bring an additional document on record, because the idea is not before my lords. I'm asking for an adjournment of only Thursday or Friday. My learned friend is right, my lord, we have sought for adjournment, but we have
Many adjournment.
the prayer has been allowed. What again has happened, my lord, is because the matter has, they haven't set a counter in the main CRP. It's listed under the file hearing caption. IA has been filed today, which is why it has not been numbered, my lord, because
That is what, it is not in record. No?
which is why I am asking for Thursday, but I didn't go on record, my lord. Post on Thursday.
Let's see, they have already taken many adjournments. You remember this matter. The matter is regarding the jurisdiction of this court, and they have failed to satisfy this court how this court has jurisdiction. Instead of they are filing this application one after the another only to linger on the matter. And the main issue regarding the jurisdiction, they are unable to satisfy, and they know that they don't have any merit. They don't have any merit.
I only like to bring to my notice that the counter in the main CRP has not been filed. My lord, record no counter is required. My lord,
Yeah.
Counter CRP.
They wanted to save the time.
No contest. I have already filed the judgment, ladyship. That will satisfy my answer.
He said, okay, you allow all this. He wanted to dispose of the main CRP.
Only record no counter has been filed, but post it on Thursday. We'll argue the matter on Thursday before paid, my lord.
No, they have already taken so much adjournment. I am paying 20,000 on each date. I am paying tickets for 20,000 for each dates.
Paid virtually also in the past. He had paid virtually. Now he's only coming to put pressure, my administration council, man. Which is why we have tried to inform them. All they are saying is, my lord, post on Thursday will argue without paid, my lord.
The simple point is regarding the jurisdiction, and nothing is there in the matter.
We'll dispose of a 9/11. Next.
Your Lordships, may I be permitted to make a mention? My Lords, serial number 72. My sincere
72 is
apologies, my
already
Lord.
senior. Serial council is also there. We have already adjourned to 17/11.
Indeed, my
Both
Lord.
council are
Yes.
present actually in that matter. Both council are present. Anyway, next 74.
Respondent number 1.
You are representing?
Respondent number 1.
Respondent number 1.
M. Sudarshan.
Sudarshan. No representation for the appellant on call. It's posted to 21 matter. Will adjourn to 7/12. 7/12.
Sir.